Okay, we are joined today by Arshdeep Kalon, who is with Kalon Law Office, I assume named after you. And we are here today to discuss flagpolling and misrepresentation. I'll provide an overview briefly of what those terms mean. But Arshdeep just won a significant case in federal court involving flagpolling and misrepresentation. Before I get into the intro, first, Arshdeep, thanks for coming on and congratulations on your federal court victory.
Thank you, Mr. Murens. Thank you for inviting me. Honestly, it's a privilege to be here with you in this podcast. When I
Yeah,
started
no.
my practice in 2019, I went online and saw your social media, listed all the cases, made a list. I still retain that list, saw, read all those cases, and that was the starting point of my practice as an immigration lawyer.
Yeah, amazing. Yeah, Steve's
Yeah,
kind of the king of social media, I think.
yeah, that's definitely on federal court cases. It's I think I've built a bit of a name
Hmm.
out there. No, that's good to hear. I've had a few people write to say similar, so it's good to see that people
Yeah.
are reading and it's benefiting people.
Yeah, but this is a
Um,
really excellent decision, and it
mhm.
so ties into stuff that Steve and I have been talking about on the podcast in recent weeks. Steve was just mentioning before we started recording that we had been sort of speculating about how a case like this would turn out, and then lo and behold, this case appeared, and Steve and I were chatting about it just over the weekend. So the timing was really quite
Yeah.
incredible.
So to set the stage a bit, 2 episodes ago, we had Andrew Hayes on, who's a U.S. immigration lawyer, and we were discussing various types of U.S. refusals, including administrative processing, which has started giving rise to procedural fairness. And at the end, we asked him about flagpolling and what the process is in the United States involving a U.S. when people who don't have visas to the U.S. flagpole, what exactly happens? And Andrew described it as sort of this quasi refusal where sometimes there's no determination made. And we commented that there had yet to be a federal court decision involving flagpolling and misrepresentation. I'd never seen a procedural fairness letter involving somebody who did not make it into the United States and was during the flagpolling process and didn't disclose it in an IRCC application and got a procedural fairness letter. So it seemed like we were kind of just hypothetically theorizing. After that episode, a listener of Borderlines wrote to Deanna to write that some consultants, I guess, had contacted IRCC about whether IRCC's position is that people who are unable to enter the United States during the flag polling process need to disclose it in their applications. And again, it all seemed hypothetical. As Deanna and I were mentioning over the weekend, Deanna and I were saying in Signal that, yeah, the federal court, knowing the way the jurisprudence goes, would probably, much to our chagrin, say that flag polling issues at the United States have to be disclosed. And then lo and behold, a few days later, your case came out, which thankfully went the complete opposite, and I know has caused quite a lot of commentary a lot amongst a lot of lawyers because it does address this topic that tens of thousands of people probably flagpole every year, and it gives rise to all these issues. So I
Could
feel
you
like I've
explain like what flagpolling is?
that
Like
was
that.
going to be the first question. So Arshdeep,
Okay,
maybe you
okay,
could
yeah.
explain what flagpolling is.
Yeah.
So usually, when people want to obtain any kind of work permit, which is basically eligible at the port of entry, those kind of work permits which people can obtain at the land port of entry, people go to the United States to, and then they are denied entry by the United States in case they don't have US visa. In case they have US visa, still they are asked to make a U-turn to show up before the Canadian side, before the CPSA, and apply for the work permits. People who are denied entries, they basically their refusal is considered as an administrative refusal, and then people who have valid US visas, they simply request the officer on the US side to go to the Canadian side, because during flag polling, the requirement is to make an exit from Canada and then make a fresh application while entering Canada. So this is what people usually do, and this is something that this client, Mr. Singh, he did in his case as well.
Yeah, so it's basically people who are in Canada, they want to apply for a work permit of some sort, either for a new work permit or to change employers. They go to the Canada-US border. I think it's called flag polling because in British Columbia, at the Peace Arch crossing, the Canadian border's up here, the US border's down here. There's a flag in the middle. And so it's almost like this U-turn where people go around the flag, even though they do try to go to the US, and come back to apply for their work permit. Why would someone do that rather than applying online?
So there are pros and cons of doing this. So most of the applicants, they make this as their choice because it is convenient, it's quicker, and also this is an opportunity to see Canadian immigration officials face to face. People believe that they can explain their case in a better way. And also, before COVID-19, the law required people to apply LMIA based work permits from outside of Canada. So basically, people who used to be present inside Canada, they were required to leave Canada, go back to their home country, and then apply. Or since flag polling is considered exit from Canada, departure from Canada, so people used to do flag polling. During COVID-19, they gave an option to people on visitor status to apply online and other people as well. If the first time applicants, they used to apply online or go to the borders. So now that policy has again ended, it is recently terminated. So we are going to see a lot of cases like this in future as well.
Yeah, and I think, I mean, there's big divisions actually amongst representatives about people flagpoling. I'm a proponent of it. I think, judging from your Instagram, you are as well, for the reasons that you mentioned. It's faster. You know, if you apply online, there's basically no right to procedural fairness or a follow-up question. At the border, you can talk to someone. Something's refused at IRCC or at a status. Getting a reconsideration can be difficult at the border. You can talk to a supervisor, regional program officer. There's all sorts of pros there. The con would obviously be that the consequence of a refusal at the border can be very serious, and involve being removed from Canada, essentially. What, when you're recommending someone whether they should flagpole or not, are there certain people that you would recommend it to and certain people who you wouldn't?
Usually, my perspective to these situations is really different. Sometimes people tell me they have these issues because of which they're scared of going to the border. For example, there was a client who recently told me that his 10-year history and his visitor visa application was absolutely incorrect and false. And this was a mistake of a ghost consultant back home in his home country. And he wanted to apply online. So I explained to him that in case we go to the border and we can explain this thing in a better and effective way to the immigration officials, in case we do it online, still we can include affidavits, do all those things in the application. But sometimes decision makers, um, they're non-responsive to those kind of submissions, and they give you negative decisions. So I believe it is a myth that border officials will pose more problems. In my cases, in my experience so far, I have a limited experience of 5 years. In these kind of cases, they are very accommodating. So people usually who have technical issues or glitches, they try to avoid border visits. So they try to do things online. I try to encourage people to go to the borders, land borders, anywhere.
Yeah, I'm generally in the same boat. Deanna, I don't know if you
I
what
think
your
it
factors are?
Yeah, it really depends. I mean, for me, it depends whether or not they have the option to apply inside Canada, or if they have to, their alternative would be to apply only to a visa office. So that is a major factor. I really do not like visa office processing at all because I feel like it's sort of the difference between having a human process the application and having a computer process the application. So that is a major factor. I think a lot of it, though, also has to do with the temperament of the applicant. I think if an applicant is very, very nervous and they're going to, it's sort of like almost like figuring out how somebody's going to do as a witness before the board. Some people just aren't very good at articulating their own circumstances. And in those situations, I would almost rather have written submissions as opposed to having them try and explain things like intent. And so it really is very case specific for me.
Yeah.
But if there are like challenging issues around intent, or, I might be a bit nervous about putting them in front of a border officer. So it's very circumstance driven.
And one thing we can say with some certainty is that the Canada Border Services Agency is not a fan of people applying at the border. They've been almost a victim, in my opinion, of their own good customer service in that people seem to really prefer to apply in person. Again, applying online from inside Canada, I mean, I can, on the Canada Border Services Agency website, skip the line, access immigration services online. You go to a port of entry, you get a decision on the spot with some recent changes to this. The online work permit extension time is currently 117 days. So it's a question of a short physical line or 117 days right now if you apply online, which is a big factor for why people go to the border. That has changed a bit recently. What's the situation in Ontario right now in terms of appointments and when people can flagpole?
So they have appointed, I mean, they have specific days for doing this thing, flag polling. Uh, I don't remember the exact days, but they have 3 days in a week they do this thing. And sometimes, even if we show up during those days, due to certain reasons, they deny to do that. They tell us to come back again due to XYZ reasons. Sometimes they're busy doing their own things. So we have faced certainly those situations as well where online it showed that they were doing this thing on that particular day, but they told us they are not in a position to do it. And since three borders, they are close to each other: Queenston, Lewiston, Peace Bridge, and Rainbow Bridge. In case one of them says no, we try other borders too.
And when they say no, is it just come back at a later time, or do you book
Yes.
an appointment for a later time?
We don't have to book an appointment. They just simply tell us they are going to do it on this day from this time to this time. So we simply show up again during those windows.
Ah, okay. And then all the way through Ontario to Vancouver, there is no dedicated time to book. In Vancouver, as of, I believe, July, or maybe it was June, there is now a strict limited window. So you mentioned, I just pulled up the website in Ontario, it's 8 a.m. to midnight at those three crossings. In the Pacific region, which includes Abbotsford, Huntington, Aldergrove, Boundary Bay, Douglas, and Pack Highway, it's Monday to Thursday from 10 to 4, and Boundary Bay is from 10 to 2. But, and what is happening, and it's the talk of our firm, it's the talk of, I'm sure, the corporate lawyers at your firm, Deanna, is you go down to the border now, and you're very lucky if you go down during those times that they'll actually process your work permit. What they are doing is scheduling people for future days, and you just get a slip. And I believe it's as we record this, it's September 6th. Last week, Douglas was booking for end of October. So that's just something to be aware of, is that at certain crossings right now, flag polling is much more complicated than it used to be. And that does impact a little bit of that pro and con of whether you recommend someone flagpole or not.
Wow. And this
We've
is like
actually got a new
true
term,
flag
air polling.
polling. Oh, wow.
Yeah, we do air polling now where people fly to the States and fly back
Oh
because
my
there's not the
goodness.
same restrictions at the airport.
Wow. Wow, that's wild. And this is not like, this is true flag polling, not people just entering for the first time, but people that are going out and then coming back in. Am I right?
So it's supposed to only be people who are flag polling, which is
Okay.
defined on this website as people who go to the United
Right.
States and are re-entering within 24 hours. Some lawyers and consultants have reported that first-time applicants are getting told that they need a schedule, and it's resolved with CBSA management. So there seems to just be a bit of ongoing uncertainty around that, but it is supposed to only be these scheduling is for people who are in the US for less than 24 hours. So, now you combine it with a trip to go see a Seahawks game and a Kraken game the night before, and you can start to sort it all out. So the other issue that arises with flag polling is what exactly goes on at the US side. So as Arshdeep was mentioning, there are people who go down and they aren't able to get into the United States. So in your client's case that you did the judicial review for, what what did the US document say?
So, in this particular case, he was never provided any document. He was simply asked that he cannot enter inside the United States before he could even tell his purpose of visit to the land border. They simply told him that you don't have a visa, you cannot enter the United States. So he explained his situation, and then they simply asked him to flagpole, and they never handed him any document or anything. They gave his passport back on the Canadian side. They kept his passport, they gave to the officer on the Canadian side themselves.
Yeah.
So
So you never got a
this was
document.
never got any document, and this was one of the arguments in the case as well.
Yeah. And I guess we should also note that the United States also is not a fan of this whole practice. Right before CBSA started its scheduling in Vancouver, Chuck Schumer, who's the United States Senate Majority Leader, was actually in the news explicitly criticizing the processes in Canada that were resulting in all these people showing up at the border saying, "Hi, I don't actually want to enter the United States. I need to flagpole to get my work permit." And so in your client's case, they didn't get any document. So why don't you take us through the facts a little bit? So what happens in their subsequent application?
Okay, so this was a spousal open work permit application. So applicant spouse, she got a PGWP 2 days before
Yeah.
he got
So
his spousal open.
postgraduate work permit. Yeah.
Yes. So she got PGWP, she came back home, and then he was in a situation where he wanted to leave for his home country as soon as possible. So he did the exact same thing, understanding this thing that it was really simple for his wife to go there, do the flag polling. She did not have valid visa as well for the United States. So she did flag polling, came back, got her PGWP smoothly. So based on the same notion, he went there. So he did flag polling, did not receive anything from the US side, came back to the Canadian side, and they gave him his spousal open work permit 2 days after his wife got PGWP. Since he wanted to go to his home country, he retained a consultant to submit a TRV application right after he came back home. So his consultant, he submitted TRV application telling him that even if it is approved, uh, you can send your passport in any visa office. Basically, in your home country, you can send your passport to New Delhi office, and they'll stamp it, even if it is approved as an inland TRV application, which is true. So after submitting his TRB application, he left Canada, went to his home country, and he waited for a decision. But they sent him a procedural fairness letter after a month or so. I don't know the exact timeline right now, but after a few days, he got a procedural fairness letter that he got a refusal. Then he had a refusal and he never disclosed it. The PFL listed the details specifically related to the United States refusal. So initially, he spoke to the same consultant, and then he prepared a response stating that he never got a refusal, but if it was a refusal, it might be a US refusal a very limited response. And surprisingly, the consultant even misquoted the facts in the procedural fairness letter again. So, but those were not relevant in the assessment, so they never came in the picture, even though we appraised the court with those facts as well. Even in his affidavit to the court, the applicant mentioned about this particular issue, that there was a mistake in the procedural fairness response as well, even though it is not part of the assessment of the visa officer. So he explained his situation, that he never believed that it was a refusal and this was something that was beyond his knowledge. So this was his position. Basically, he was somewhat touching, to me, he was somewhat touching ignorance of law, that this
Yeah.
was not something that he understood. So the response to me was not very up to the mark, but he got a refusal, and the reasons for refusal were very non-responsive to his submissions. They were very blanket reasons, that they're still not satisfied. But why and how the officer was not satisfied, that he was not able to satisfy the concerns of the officer, it wasn't mentioned in the reasons. This was main argument in the
Yeah.
case.
And he doesn't just get a refusal, he gets a misrep ban on entering Canada for 5 years.
Yes. So usually when people contact me and they bring their cases, uh, and they don't have misrepresentation bans and they want to go to the court, I discourage them, because their applications usually they're not up to the mark when they're done by non-lawyers. So I encourage them to reapply and discourage them from being a burden on the public purse, thinking that this might end up getting into a negative decision again from the court as well. So in this situation, we did not have this choice. So we went to the court and got rule 9 reasons. When rule 9 reasons came and my articling students, they were sitting with me. To them, I said, I think the leave wouldn't be allowed. Just like you mentioned about your podcast, that jurisprudence on this subject is really strict, and even Section 40 itself doesn't talk about intention, and the provision itself is really strict. So I told my articling students, I think he won't be able to get the positive decision prima facie, and let us start preparing the case. So we prepared the case, and then uh, I wasn't hopeful that leave will be allowed, because I was still 50-50, given the nature of the provision and the circumstances. It was very much, I mean, the anticipated argument would have been, I knew that this would be the argument, that this was something already within the knowledge of the applicant. How can he say that it was an honest mistake, because he never knew that this was a refusal? So
I
we
want to
were
pause
worried.
on that. When you're just on a practice tip, knowing how many junior lawyers listen, when you're writing your memo of argument and you know this is going to be the counter argument, do you address that? Like, did you hear address that upfront in your memorandum of argument? Or do you wait for them to make it first and save it for a reply if they raise it?
I always try to save it for the reply, because
Yeah.
I don't want to give my complete line of action. So I try to be very straight in my arguments. So they're always brief, straight, but comprehensive again. But I don't touch the arguments that the other side is required to make. So in my case, we did the exact same thing. We did not touch these things. So we mentioned everything related to the Rule 9 reasoning, other arguments, honest error, and all those things. And there is a narrow exception to misrepresentation cases. We pleaded those in the arguments as well. And then the leave got allowed, and the client was really happy that leave is allowed. So I told my client that my job is over, the leave is allowed, even though I'm required to do the further process. But this was the main goal, that there is some kind of substance in the case, that the leave is allowed. So he continuously pressed me about the outcome. He wanted me to speak on the outcome of the application. And throughout my discussions with him, I kept on explaining him that this is a difficult situation and the law on this thing is really strict. So he wasn't very hopeful. And even after the hearing, he spoke to me, and I said everything looked fine. But in these kind of cases, anything can go. I mean, the decision can go on either side, because the arguments from the other side were equally strong and good.
Mm-hmm.
So we were not sure even after the arguments.
Was your
But
focus in your submissions mostly on the materiality of the misrepresentation or on honest mistake?
so materiality of the decision which the court even took into consideration, this was one of the arguments. This
Mm-hmm.
was only one of the arguments, but we raised other things as well: limited reasoning, insufficient reasoning while arriving at a
Mm-hmm.
conclusion, breach of Vavilov, breach of recent
I
cases.
see.
Yeah.
Yeah.
I
So
don't think we've had a judge on before to talk about how they view arguments at judicial review, but I don't think we've discussed it on the podcast. Maybe do you want to just also provide an overview of like what does a judicial review look like? Like, is
Mm-hmm.
it in person? What's the order of who argues?
do you want me
Yeah,
to
yeah,
answer
for
the
sure.
question? Or do you want-
You're the
Okay.
most you had the most recent hearing.
Mm-hmm.
Okay. So during in-person hearings, the applicant side is asked to present the arguments first, oral arguments, and uh, based on their book of authorities, based on the cases that they submit to the court, that these will be the cases based on which we will argue, and based on their written arguments, they plead first, they represent the applicant first, and apprise the court with the facts, briefly outlining all the material facts and the background of the matter and how the situation ended up and how the applicant received a negative decision and misrepresentation ban in this particular case. I explained that. And then after that, we jump onto the arguments why we believe that the decision maker gave wrong decision and the decision making was incorrect. So we explained everything to the court. In between, the court had certain questions, and also in this case, the since the response to the PFL was uh, incorrect. They had basically mentioned that both of them went together to the border to obtain work permits, and one got PGWP and another got spousal open work permit, whereas they went on separate dates. So judge had little confusion on this particular fact because this wasn't clear to the court that whether they went together or on separate dates. So they had questions like this, and in between they questioned us related to the facts and also based on the arguments that we had submitted to the court.
Yeah. So you
So
speak, you're in your robes, and then
yes,
after you speak, Department of Justice gets their turn.
yes. So they get their turn and they again checked about the facts from the Department of Justice. He had a basic argument because in this case, again, the provision and everything supported his side of arguments. So he gave very brief arguments and then explained his side of arguments to the court. And court had some questions from the Department of Justice. And after that, we got an opportunity to reply back to the arguments of the Department of Justice. And usually, this is what happens in case the lawyer of the applicant believes that there is something that needs to be addressed, or there is some misquoted fact, or there is some confusion, or in case they want to reply specifically to a specific argument of the Department of Justice, they stand up and explain their case to the court. And
Yeah.
Mm-hmm.
then finally, the case is over, and the judge sometimes still has questions. Usually, they by then, by this stage, since this is the third time the council is speaking, first the applicant's council, then Department of Justice, and again the applicant's council stands up. Usually by then the court is clear on the arguments and facts and everything. So
Mm-hmm.
And 9 times out of 10, if not higher, it ends not very climactically. It usually just ends with the judge saying, I'm reserving my decision,
Mm-hmm.
which
And
yes,
just,
this,
yeah,
the thing about federal court too, it feels quite a lot like moot court, in the sense that all of the arguments have already been pled in written submissions, similar to the order of pleadings that you've seen that Arshdeep has described as happening. So, there's the same order of pleadings, the applicant's record, and then the respondent's reply, and then the applicant can respond to that. And so and the judge comes into the courtroom having really fully read those pleadings. There's no witnesses in the hearing. So speaking to the junior lawyers that are listening, it is a very good opportunity if you're interested in getting into litigation to start here, because the dynamics in front of the board where you're dealing with live witnesses and it's just there's a lot more going on, whereas federal court is you know it's a sort of a cleaner hearing, so to speak, in the sense that most of the arguments have already been made.
Yeah, there's some
Since you
judges who don't ask any questions. Like it's,
Mm-hmm.
yeah.
Yeah, yeah.
Yes, since you just mentioned about junior lawyers, uh, another counsel with me who uh, did the hearing, his name is Gursukman Singh, and I think you mentioned in the email that you sent to me his name as well. So Gursukman is a new lawyer. He just became lawyer, I think, 2 years ago, less than 2 years ago. So this was his first in-person hearing,
Oh
and he
yeah.
was really excited. And we divided our submissions in two parts. I wanted him to experience everything because he's the one usually helping me in so many things in my
Mm-hmm.
office. So he did the submissions, the first part of the submissions and arguments. It was done by Gursukman Singh.
Mm.
And then, in reply to the Department of Justice, I had to stand and request the court to uh, give my submissions because he missed some of the facts, and also he wasn't very clear on the facts of the case. So the initial question of the court regarding the dates and the process that was adopted to apply for work permits, Gursukman confused the court a little bit, and then I intervened to explain the facts again a little bit.
Mm.
I went back to the first question and then responded to the concerns of the court and also addressed some of the arguments of the
Mm.
respondent. So these
That's great.
submissions were done by both of us.
Oh, that's
Yeah.
great. Well, it's a good opportunity for mentorship there. I remember the very first time I ever appeared in federal court, I called who was it? It was Chris Elgin. And I was like, Chris, I went into his office and with my pleadings, and he just like, make this argument, not that one. This one's going to be stronger. Focus on that, you know. And he just sat with me for a couple of hours and coached me, you know. And so, but I think, you know, within our very collegial practice area, there's generally somebody who will bring you into court, you know, allow you to second chair and do what
Yeah.
Arshdeep has done for Gursukman, and give you an opportunity to try your hand on it or play judge for you and let you try arguing your case in advance of your hearing. So,
My first one was with Lorne Waldman,
oh, wow.
was arguing co-counsel.
There you go.
And again, it's a great learning opportunity. Yeah,
For sure.
I saw that Gershukman's name was listed as co-counsel, so that's a cool opportunity for him.
Yeah.
Initial plan was that Gursukman will take care of everything from end to end, but it got little derailed during the hearing. So, but the court was very accommodating. Justice Grant was very accommodating in this
So
matter, and
do
he was.
you explain that to your client? There's another question that I know, I guess more practice managementy is, do you explain to your client that your junior is going to be doing the arguments? Like, how do you navigate that?
So yes, so in my retainer agreement, I clearly mentioned this thing in writing right in the beginning, but I don't leave it up to the retainer agreement because sometimes people don't read them or clearly understand things. So this is always mentioned in my retainer as well. But before the hearing itself, because clients these days, they are digitally smart, they get to know. And even as my professional obligation, we are required to inform the client about each and everything. So I had fully informed him about Gursukman saying doing everything, and I had mentioned that everything is prepared by me, everything is it is my line of action. So he will be the one who will be doing oral arguments, and he was absolutely fine with it. And he just said that if you are confident, I'm confident you can do this if you want to. So he was okay with it. And then initial practices, just to mention in my retainer agreement itself, that somebody else might be doing the hearing as well, or somebody might intervene during the process.
Yeah, I love that approach, Arshdeep. Done a very similar thing. And actually, I've just brought on a new associate, Priscilla Piedmont, who's going to be starting with me full time in the weeks to come. But I took a very similar approach, including it in my retainer agreement, but also being very clear, having her sit in on certain meetings and then explaining that this is how it was going to work, but that we're still collaborating on cases, and that, that I'm still going to have oversight, and, and it's the very same kind of, clients saying, yes, if you're comfortable, I am too. And so it's a nice way to kind of bring somebody in and building that confidence for both the client and for the associate.
Yeah. And so then you get the decision. You must have been thrilled.
Yes. So first,
Such a good
Gursukman,
feeling.
yes, it was a very good feeling. And then Gursukman, right after receiving the decision, Gursukman read the whole decision, and then he was so overwhelmed reading it, and he said that I'm still not in a situation to understand what the judge has said in the decision.
When you read it, you're just like, allowed, denied. Yeah, you're just
Yes.
not even reading the words.
So this is what he did. He had a copy of the decision, and then he went, scrolled all the pages, and went on the last page. Oh, thank God it's allowed.
Yeah.
And then he started reading the decision.
I did the same thing when I just got the decision on my Kayali case. I was I had so much writing on that one emotionally that I just like turned to the last page. I read the decision. I sent it to the client before I'd even finished reading it, and then I finally sat down calmly with a cup of coffee and actually read the
Yeah.
reasons.
So, and the surprising thing was that on after September 3rd, the client's phone is switched off, and we were not in a situation to. We sent him an email, never got any response. His phone was switched off. He got to know about the decision last night, yesterday, and
Uh,
we spoke with him. So,
yeah,
Uh,
yeah,
nice.
yeah. Did
Let's
Gershikman make the call or did you do it?
I called him.
Okay.
but let's get into some of the passages here that discuss this issue of misrepresentation and flagpoling. I've got the case in front of me. And so I'll just read a few of the key points that really I found that it's not, sometimes you read decisions and it's sort of unclear how it will go on redetermination because,
Yeah.
it's basically based on the officer's reasons being insufficient. But I feel like here Justice Grant's decision shows that he got it.
Yeah,
And on
for sure.
redetermination, I I think this case will stand for the broader proposition that
For sure.
um, flagpoling issues with entering the United States don't constitute enforcement actions that need to be disclosed, or if an officer is going to go otherwise, they really need to explain why and counter and explain why they're almost deviating from this case. So just at paragraph 26, um, Justice Grant writes that central to the context of this case was that the applicant did not know he had ever been refused entry into the United States, and that this refusal arose solely from the flagpoling contact process. Contextually, it was also important to consider that the applicant did not actually seek entry into the United States, but was simply following a common procedure, one permitted under Canadian immigration law to extend a visa to remain in Canada. Um, and, moving down in the decision, it was important for the officer to consider that the applicant who wasn't represented by counsel, whether it was reasonable that he was unaware that a U.S. entry refusal was a byproduct of the flagpoling process, which, as we've discussed before, and as we had with Andrew Hayes, it's really unclear how exactly the United States records it, what exactly it is, and within the context of a process that Canada has, whether someone essentially needs to disclose that they followed that Canadian process.
Hmm. And so I agree with the things, the points you've pulled out. And while Justice Grant sticks with the question of sufficiency of reasons, I think that at paragraph 20, he does speak to the Gill case, which is the one that we've all been clinging to for dear life since it was proclaimed in 2021 about that innocent mistake exception, that an innocent mistake needs to be something beyond the applicant's control. And while, not declaring that this would be an innocent mistake, Justice Grant does say, that when that the exception should be applied where honest error has occurred, and just sort of tip the hand a little bit by saying, I share Justice McAfee's concerns, and while I will not make a decision on this is at paragraph 21, that the decision here was unreasonable based on what was actually present. So to me, that's like a bit of a tipping of the hat that, like, I'm not going to find that this was an innocent an innocent mistake, but to me, this is a bit of a show of
Well, and then the second final paragraph, which gets into materiality, and I'll just read it. As mentioned above, the process of flagpolling seems to result, as a matter of course, in a denial of admission into the U.S. If this is the case, the process itself would not appear to result in an inadmissibility or a failure to meet the requirements of the Act. If it were otherwise, the process would not exist, as everyone who did it would have to be denied re-entry into Canada. As a result, it is difficult to comprehend how a failure to mention a flagpolling attempt in a subsequent visa application is on its own particularly material to that application. Perhaps there are other reasons why the applicant's attempt to flagpole raised material concerns, but those are not apparent from the officer's reasons, and so the decision is unreasonable. When I read that, I just went, exactly. Exactly.
Yeah.
And then I messaged Deanna and said, we have to do an episode on this.
Yeah, 100%.
Got to invite Arshdeep.
This second last paragraph of the decision.
Yeah.
So our argument, this was one of the minor arguments, and we never thought that this will be the main conclusion of the court. This was one of the minor arguments from our side, and then the court has articulated this thing really well. Our argument was limited. Why I'm saying minor argument, because um, our argument was limited to this thing that the applicant got approval on his spousal open work permit, even if he would have declared it in his application, or even if it was not declared, he was still eligible for TRV. For there was no reason for him to hide this thing. Had he known that this was a refusal, he would have simply listed this as a refusal as well in the form. So we had argued this particular thing in this way, but the court has explained it in a very nice manner, I would say.
Yeah. I do always include arguments on materiality, and I understand that they sometimes go against this bulk of decisions. They might not be, and Steve, I know, thinks that I'm very idealistic in terms of these types of arguments. They're not necessarily ones that are supported by a great volume of jurisprudence, but call them aspirational arguments because to me, they're common sense arguments that this type of a thing, the idea of finding them to be material, to me is just, it's ludicrous. And so I love this common sense approach. I think it's brilliant.
You'll never get what you don't ask for.
Yeah, 100%. Go for it.
As lawyers, I know it is important to get a good decision for the client.
Yeah,
But
yeah.
as lawyers, I believe once we are in the court, once we do our job, once it is over and the decision is reserved for a later date, in these kind of situations, as lawyers, when we argue, and the first thing that I do to myself is whether I did a good job or not. In this case, I was satisfied that from our end, even though everything is against us, we did a very good job. And even the court said to Gursukman that this was a very good hearing in terms of when it comes to a first hearing, first in-person
Yeah.
hearing.
Oh, sweet. That's very nice. Well, we second the motion. Good job.
Yeah. How do you go out how do you unwind after the hearing? Did you
Yes, we
and
spoke.
Gursukman, I don't know if it was a morning hearing or an afternoon, you go for a drink, do you?
So before hearing, so what we do is we go to Toronto downtown before hearings, and we stay in a hotel every time we have hearing, and then we do our fun a day before, and then
Aw.
after hearing, it was a morning hearing, and after hearing, we usually head back to our office because then before hearing, 2 3 days are gone and preparing everything, and
Hmm.
a lot of phone calls and everything is always in the pipeline. So we enjoy before the hearing instead of after the hearing.
Oh, that's excellent.
But after hearing, we spent some 15 20 minutes with the opposing counsel, and it was a good conversation on misrepresentation. He gave us some input on how they speak with their clients and what issues they face when
Mm.
it comes to settlement requests. And in this particular case, he mentioned that he never believed that this was a settlement case, and he explained more on settlement side.
Yeah. No, it's I often go for lunch or a drink after with
Mm.
DOJ, assuming my client's not like with me and I'm hanging out with them.
Yeah.
Um, yeah, it's
So
I
next
used to do it
time,
right after the hearing. Now we change out of the robes because I went once in the robes for coffee with the DOJ counsel, and I felt people rolling their eyes as they walked by.
Yeah, no doubt.
But
so
No
next
doubt.
time we'll follow. Next time we'll follow this approach.
Yeah. Yeah.
yeah, it
Yeah, it's a good call.
yeah, well, congrats again. It's
Yeah.
like it's just it was such a fun like the timing of it all was so funny because we had
Yeah, it's
just
hilarious.
discussed it and it resolves, I think, in a very good way and sensible way, the issue of this just big question that gets raised because again it's a decision. Your decision is one that impacts tens of thousands of people each year.
Hmm.
So
Thank you
I
so
hope you
much.
and Gersukman are happy.
I
I
have
hope
a
he
Yes.
final
listens.
question, which is now that we've seen this, do people think out of an abundance of caution that you should still be disclosing it to avoid this type of procedural fairness letter in the future? Or do we think that this is a clear pathway to say this is not something that ever needs to be disclosed?
So I would still advise people to disclose everything properly, and I would caution everybody to be more diligent when they do their applications. And specifically, this is my personal opinion. In case you receive a procedural fairness letter, do retain a legal counsel. Do go to barristers and solicitors to take opinion. Even if you don't want to proceed with the legal counsel, at least do a consultation with the legal counsel.
Yeah.
This is
Yeah.
my opinion on this.
I mean, it's one of those things where, like, if you're asked, there's no upside to telling someone not to disclose
Yeah,
it.
100%.
Yeah.
And it's just whether or not you even bother asking people, have you ever flagpolled in the past? Because, like I don't even ask people that question. It's like, you know, it's
It's
we
crazy.
we used to ask verbally, but this was not part of our questionnaire
For
since
sure.
last year we added this particular questionnaire.
I guess once
exactly.
bitten.
I know you went, whoa. I saw it show up in an FBI certificate once for someone, a
Oh,
flagpole, and I'd
wow.
only seen it once. I have no idea why it appeared there. I asked, did any like, were you detained? No, I just went to the US. They swiped passport, and it showed up in an FBI cert.
Oh
So
my
again,
God.
it's
Again, our
I,
role is to avoid problems in the future. So if that's our job, it's like, I think I'm adding it to my questionnaire too?
yeah,
yes.
Yep.
Every day when we, in my case, when I practice, my goal as a third generation lawyer is to encourage people to. I mean, I work for the repute of lawyers as well. I don't want them to think that they're only following street standards, they're saying anything. So we encourage people to be very meticulous, diligent in their process, and this is what I have to say.
Yeah.
nice. All
Agreed.
right. Well, thanks for coming on. I hope
Yeah, it's wonderful chatting.
yeah.
Thank you so
And
much for inviting me once again, and it was a great opportunity and pleasure as well at the
Yeah,
same time.
yeah,
for us
hopefully we
too.
can all be in the same city and meet soon.
Yeah,
We will,
definitely.
in case I come to that side of the country, I'll surely
You
let
let
you
us know.
Yeah.
know. Sure.